Hey there, welcome back to yet another episode in the series of videos where we are discussing designAct in the most simplest manner. In our previous sessions, we took our application through the examination phase, got it accepted, have received the certificate of registration, got to know that we can enjoy our copyright for the period of 10 years, which can be extended by further 5 years if we wish to. But what are these rights, and do we have any responsibilities or obligations to ensure that we keep enjoying our rights? So in this session, we are going to talk about the rights that we have and what are the terms and conditions while we enjoy these rights, and how we can safeguard these rights from other users. Let's get into the session. Let's take this designer watch to be the article that we have obtained the design registration for. So what rights do we have? So as per section 2C, which is copyright, C copyright, section 11 and section 44, we have the exclusive right to apply the registered design to the article or articles. This is the right that we have. So when we say that we have the exclusive right to apply the registered design to the article, we indirectly say that others who don't have my consent cannot apply the registered design on any articles for sale. Perfect? But are there any obligations, are there any requirements that I need to take care of so that I can enjoy my exclusive right? Let's go over them. As per section 15 and rule 26, before delivery on sale of any articles for which you have obtained the design registration, you are under obligation to mark such articles with appropriate words and number which can indicate that the design is registered. Markings such as registered, REGD, RD, and registration number of the design should be available on the article. Now, there are few exceptions on what all cases you may not need to do this. If there are soft or brittle articles, you may not need to do this. Similarly, for textile goods, charcoal, dust made goods, and there are few exempted classes issued by the government for which you don't need to make such markings, or for multiple classes of articles you don't need to put registration numbers for all the design registrations. You may wonder, why do I need to provide such markings? See, the markings are kind of notice to the public at large that this design is registered. So please don't copy it. Don't do piracy of this design. So you are playing fair by letting everybody know that the design is registered. But if you were not to do it, then you will not be entitled for any penalty or damages in case of infringement. You can of course have your way out by saying that you did your best to mark the articles, or the infringing party was aware of the registered design. With that awareness also, they went ahead with the piracy or infringement of the design. So you have your way out, but it's prudent to put such marking on your product. Similarly, you have certain obligations towards the patent office. If you have not deposited the required representations or specimen as requested by the controller, then your registration will be revoked. Therefore, it is important for you to ensure that your articles are marked and your obligations towards the patent office with regards to the documents are fulfilled before you go ahead with delivery of your articles. Moving on, section 22 talks about piracy of registered design. Basically, it states that it will be unlawful or illegal for any person to apply designs on articles for the purpose of sale, importing such articles for purpose of sale, or exposing or publishing articles with such design or imitation of design for the purpose of sale without the consent of the proprietor. In case the piracy or infringement is done by the third party, then the proprietor of the registered design can institute a suit of infringement against the in case such a piracy or infringement is done by the third party, then the proprietor can institute a suit of infringement against these parties for recovery of damages against the piracy of the design. This, of course, can only be done post registration date till the expiry date of the copyright of the design registration. So these are the rights of the proprietor of the registered design. With this, we are done with this session. We understood the rights that we obtain after our design is registered, the copyright, the duration, and what all can we do to safeguard our interest in the design registration. In the next session, we will discuss the scenario of what happens when we forget to renew the design registration. What are the ways and means to restore our application? Till then, take care and goodbye.